So you have discussed about how various parts of essentials of a contract or an agreement, right? We discussed about how to start a contract or how to enter into agreement. What are the capacity of parties, and what is the consideration? What are the essentials of it? Today we'll be discussing about the various modes of discharge of a contract. So how does contract complete, or how does contract be discharged in the eyes of law? When a contractual relationship subsisting between the parties come to an end, the contract is said to be discharged. So when two parties have entered into an agreement, right, either to buy, sell, or whatever the object of the agreement is, if they have fulfilled it, completed it, then the contract is said to be discharged. Discharge is the end of the contract and termination of contractual relationship. So it not only ends the contract but also the termination of contractual relationship. If Mr. A and B entered into a relationship, entered into a legal relationship to buy or sell certain goods, once they have completed that act, then they are no more bound by that contractual relationship. Okay, they are being terminated once they complete the obligations of the contract. So this is the meaning of discharge of contract. Now discharge happens by six various situations. The first one is by agreement, second is by performance, third is by impossibility, fourth is by lapse of time, five is by breach, and sixth is by operation of law. So these are the six different situations where a contract can be discharged. Let's discuss each of it. First one is discharge by agreement. Since a contract is formed on the basis of an agreement, it follows that the contract can be discharged by a mutual agreement. Section 62 and 63 on the whole provides the ways in which the discharge of contract by mutual agreement is explained. Now, when we say it is by agreement, that means both the parties have agreed to it, okay, to discharge a contract or terminate the contractual relationship by making sure the obligations are fulfilled. So, the first kind is discharge by agreement. Now, there are six different modes of agreement: novation, rescission, alteration, remission, waiver, and merger. These are the six ways or six conditions under which the agreement can be discharged. That is called as the modes of agreement. Let's look at the first one, novation. What does novation refer to? It refers to the substitution of a new contract for the existing one. So what is novation? It is substitution of a new contract for a existing one. So basically whatever agreement you have previously made, priorly made, you are making another contract, a new contract in the place of the original contract. That's called novation. It can be either between the same parties or between different parties. And the consideration for the new contract is the discharge of the old contract. So when you're forming a new contract here instead of the original one, either you can have the same parties which were in the original agreement, or you can create between a different parties. Is that clear? That is called as novation, substituting a new contract for the existing one. There are certain rules for it. The first one is it must appear before the expiry of the time of performance. Now remember, you already have made an agreement. That agreement date, right? There is a particular date where you need to execute your obligations, correct? Before that date completes, before that expiry time completes, you need to renew your contract, or you need to create a new contract. When? Before the expiry date. Second rule is it should have mutual consent of the parties. It's not that one party agrees and the other does not. No, both the parties in the original agreement must agree that let's create a new contract in the place of original contract. Third rule, it must have been substituted to the present contract. An agreement to institute a contract in future will not be novation. It should be a present contract. Right now you want to execute it, but you do not want to, so therefore you want to create a new contract. You cannot recreate a contract which is somewhere in the future, after a year or 2 years. Okay, those agreements you cannot recreate or create a new contract, but then the rule says that only present contracts can be renewed. Next, as a result of novation, the contract is totally discharged and law does not entertain any action based upon the terms of the old contract. So once the new contract has replaced the original contract, the old contract is totally discharged. Okay, the original contract does not have any legality in the eyes of law. It is completely discharged. The law cannot take any kind of action based upon the terms and conditions of the old contract. Whatever is created new, that will be legal in the eyes of law. In novation, the new contracts must also be valid and enforceable. So again, when you're creating a new contract, you need to follow all the conditions that we have studied. Essentials of a valid offer, valid acceptance, consideration, capacity of parties. All these rules must again be followed up to make sure the new contract is what? Valid and enforceable by the court of law. In case if it is not, then the parties remain bound by the original contract. Only when the new contract is not valid and enforceable by law, then the parties are bound by the original contract. For an example, if A owes to B rupees 10,000 under a contract, okay, now here the example says is A has to pay rupees B 10,000. So A owes 10,000 rupees to B. In the same context, even B owes rupees 10,000 to C. Is that clear? A owes to B and B owes to C. Amount is same, 10,000 for both the cases. Now what B here says is, instead of A, you paying me, why don't you pay directly to C? Okay, the agreement is between A and B, correct? To pay rupees 10,000 for whatever work he has done. But what B says is, instead of writing my name as the agreement, why don't you create a new agreement that is called as novation? Okay, creating new agreement in the place of old agreement stating that A has to pay C now. Is that clear? That was the condition laid down by B or suggestion. But C does not assent to the agreement. Now what did we tell you? The first rule is what? The second rule was what? Mutually consent of the parties. Okay, both the parties must agree to it. Now if C is the new party in the new contract, but if C is not willing to enter into the contract or agreement with A, then you cannot recreate the contract. Is that clear? Novation does not come into this picture. Is that clear? So what does the last point say here? In novation, the new contracts must also be valid and enforceable. C is not willing to enter into an agreement with A. Therefore, it is not valid, it is not enforceable by law. If not, what has happened? The parties remain bound by the original contract. So in this example, C did not agree to have an agreement with A. Therefore, now still B owes C rupees 10,000 and no new contract has been entered into. So everything gets back to normal. Again, A has a contract with B to pay 10,000 and B has a contract with C to pay 10,000. Is that clear? If parties don't agree, mutually agree to it, then novation does not come into picture. Only your original contract is, you are bound by the original contract by law. Second mode of agreement is rescission. The word rescission refers to cancellation. Well, novation results in a new contract in the place of the old one. Rescission results in the cancellation of the original contract. So in novation, what did we study? That we are creating a new contract in the place of original contract, correct? Now rescission here means simply cancelling the original contract. Is that clear? With a mutual consent, of course. You are just cancelling the original contract. That's why the statement says novation will result in a new contract in the place of old one, but then rescission results in the cancellation of original contract. It simply means cancelling the original contract. Number 3, alteration. This is the third mode of agreement. Alteration refers to a change to one or more of the material terms of the contract. It must be made with the consent of the parties. Now remember, alteration means what? Make changes. Okay, make the necessary changes. Now here, it has to happen with the consent of the parties. A cannot alter the agreement, the terms of the agreement, without the consent of B. Both must mutually agree to the alteration of the material terms of the contract. Here's an example. A has a contract with B to supply the goods at his warehouse on 1st July. So A has promised B, I will supply the goods to your warehouse on 1st July. Later, both party A and party B both agree mutually to postpone the date of delivery of goods on 30th November. So this change turns to alteration of the contract. So alteration means they're not cancelling it, they're not recreating it, they're just making the necessary changes to the contract or altering the contract by the mutual agreement or consent of the both the parties. Is that clear? So both had agreed upon 1st July and then both are again altered the agreement to 30th November. Still, this agreement is valid and enforceable in the eyes of law. Number 4, remission. Remission may be defined as the acceptance of a lesser sum than what was contracted for or a lesser fulfillment of the promise made. Remission means what? Acceptance of lesser sum. I want you to remember this word. Remission means acceptance of lesser sum than what was contracted for. Example, A owes to B rupees 2000. A is liable to pay to B 2000. A pays 1000 to B and B also accepts in the satisfaction which 2000 were payable. Therefore, the whole debt is discharged. What was the agreement for? Rupees 2000. How much did A pay? Rupees 1000. Did B ask for the remaining money? No. B fulfilled or B accepted in satisfaction for rupees 2000. So when B itself, the party itself is agreeing for a lesser sum of money than what was contracted for, then the whole debt is discharged. In case B says no, you have to pay the balance 1000 rupees, then A must have to pay. But since B is accepting the 1000 rupees in satisfaction, notice that word, in satisfaction, where 2000 was payable, then he is telling that it's okay to pay 1000 rupees in place of 2000. So this is called as remission. Is that clear? Accepting a lesser sum of money. Fifth mode is waiver. It refers to abandonment of a right which a person is entitled to. What is remission means what? Accepting lesser sum of money. What does waiver means? Abandonment of a right which a person is entitled to. A agrees to repair the car of B. B later on forbids or refuses A to repair the car. A is no longer bound to perform the promise. Thus, the contract is terminated by waiver. Now here listen the example. A agrees to repair the car of B. Now A and B enter into an agreement that A, you repair my car and B will pay the consideration for repairing the car. Now later on what does B say? You do not have to repair my car. He only refuses A or forbids A from repairing the car. The very purpose of the agreement or contract was for what? Repair the car and the payment will be given. But then if B is stopping A or B is refusing A to fulfill his obligation, which is called as waiver, A is no longer bound to perform the promise. Okay, since B has refused A to perform his obligation, then he is no more liable to fulfill his promise. Therefore, the agreement is terminated by waiver. Is that clear? Number 6, merger. Merger takes place when an inferior right accruing to the contract merges into superior rights. Now, merger we commonly call this as what? Two companies coming together. That's a common understanding, correct? Now, under contract, what is the meaning is? Merger takes place when an inferior right accruing to the contract merges with a superior right. So, there is an inferior right that is being compared or that is being merged with the superior right. Example, A purchases a house which he was having on lease. His right of lessee is inferior to the right of the owner. Now you tell me, if the lessee, if you are living in a house on lease, you have taken the house, you can take a house on rent or on lease purpose, correct? Now you have taken the house on lease for a couple of years. That you are just a lessee over there to the owner, correct? You have paid a huge sum of amount of money for a couple of years to stay in a particular house, and then once you vacate the house, the money comes back to you. So you do not have much rights upon the house over there. But then here in this example, what is A doing? He is purchasing the house. That means he becomes the owner of the house. So don't you think the rights of a owner are more superior than the right of a lessee? Correct? Lessee is a person who is just residing in the house, where some or the other day he has to vacate. Whereas if he is the owner of the house, it is his own house. He can live in that house for n number of days. So merger means inferior right accruing to the contract merges into a superior rights. So first he was a lessee to the house. That means he has taken the house on lease. Now he has bought the house or purchased the house. This is called as merger. Is that clear? So these are the 6 different situations under which discharge of a contract happens by agreement. Point B, discharge happens by performance. So when both the parties, that is performance of the contract, is a usual mode of discharging a contract. That is, when both the parties have performed their obligation, the contract is said to be discharged by performance. Notice that word, both the parties have performed their obligation. Is that clear? Now, if A is promised to sell his house for rupees 5 lakh to B, A has sold his house and B has paid the price of 5 lakh. So, both have performed their obligations here. That way, the contract is discharged, or the contractual relationship between A and B is being terminated. The third condition or the third situation is I am discharging the contract by breach. When a party to contract fails to perform his obligation, he is said to have committed breach of contract. So I promised to perform certain activity or sell something, but I am not doing it. Is that clear? I am failing to perform my obligation as agreed upon in the contract. What is it said to be? It is called as breach of contract. It can be in 2 ways: actual breach of contract and anticipatory breach of contract. What is actual breach of contract? This can take place in 2 ways. First, at a time when performance actually due. So you are yet to perform the contract. It is yet due. In this situation, if a party to a contract fails to perform his obligation at a specified time, he is liable for his breach. Example, A agrees to deliver a furniture worth rupees 10,000 to B on 31st March of 2005. but fails to do so on that date, he is said to have committed a breach of contract. Now, A had time until what? 31st March to deliver the whatever goods, okay, to deliver a furniture in this example for rupees 10,000. He had particular time. In case A was not able to fulfill that, he should have informed B previously, or he should have altered the date. You remember we just studied by agreement. Under that, one condition was what? Novation. If you're not able to fulfill certain conditions, you can create a new contract in the place of original contract. Or if you remember the alteration condition, what did they do in that example? They just changed the date by a mutual agreement. Why? Because both the parties agreed to it. But here A is not communicating that he is not able to deliver the goods on 31st March to B. Finally, when the date of obligation to be fulfilled occurred, A backed out. So A did not fulfill his obligation by delivering the furniture to B. Therefore, this contract is said to be committed a breach of contract. Whose mistake was it? Mr. A. Second part is breach during the performance. Now there is actually the contract or the obligation of the contract, the party is performing. It is during the performance, okay? And then during the performance the breach occurs. It occurs when one party fails or refuses to perform the obligation under the contract's the performance of the contract. Now here what happens, let me say an example here. Now usually if let's say for an example, a company has a contract with the supplier to perform certain supply certain raw materials, okay. Each month they have to supply 100 kgs of cotton per month, okay. Now they're both the parties, supplier and the company, have mutually agreed and created a contract. And so every month the company for 1 year, the contract is every month they have to provide 100 kgs of cotton. Now supplier has been supplying accordingly as company has agreed to. But then after 6 months of the contract, okay, this is during the performance. Got it? During the performance, company says we no more need cotton. Okay, you can stop the supplying of cotton to us. Is that clear? It is during the performance that the company is stopping the supplier to provide any kind of further supply of raw material. This again results in what? Breach of contract. The last point, anticipating breach of contract. When a party to a contract has refused to perform, here what happens? In the other case, company stopped, but here voluntarily the party has refused to perform his obligation before the time fixed for performance is known as anticipatory breach of contract. So basically here one party is informing the other party, I will not be doing this activity what we agreed upon. I will not be willing to supply you the goods. So he is outrightly refusing the other party that I will not fulfill my obligation. But the date of fulfilling the obligation is yet to come. Notice the time, notice the second line over there, before the time fixed for performance. Okay, so next month I have to supply, but then now only I am telling I will not supply the goods. I refuse to supply the goods. Is that clear? So this situation is called as anticipatory breach of contract. Why is it called as anticipatory? Because it is yet to be performed. The date is yet to be fulfilled. The obligation is yet to be fulfilled. Is that clear to all of you? So today we started with various modes of discharge of a contract. We discussed we knew there were 6 different situations where we can discharge a contract. We studied discharge by agreement, It happens in 6 different cases. First one is novation, that is replacement of original contract. We discuss the rules. Then we discuss the second rule, second mode of agreement, rescission, which means cancellation of original contract. Third, altering the material terms of the contract. Fourth, remission, that is acceptance of lesser sum. Waiver, that means abandonment of right. Merger, that is inferior right merging with the superior right. Part B, discharge by performance, that means both the parties mutually perform the obligation. Third is discharge by breach. Two conditions, actual breach, anticipatory breach. Under actual breach, we studied two kinds: at the time when the performance is actually due, second, during the performance, and the last one, anticipatory or anticipating breach of contract.